we're here on a Monell trial because this is what they do to people. And then when this came up during the trial, the defense expert, Edward Flosey, testified, well, this is what Post trains officers to do for stops of suspected stolen vehicles. And as the court can see, and as I put it in the brief, there was a colloquy with the district judge. And I said, that's directly contrary to Green, which says the Washington versus Lambert standards apply to reasonable suspicion for stolen vehicles. A suspected stolen vehicle is not the kind of crime that automatically triggers these extreme measures during Terry stops when there's no probable cause to arrest. And the response from the district court was, well, Post can train something that is not consistent with the Ninth Circuit. And when it came to the jury instruction, I said, the jury needs to be told that when there is a Terry stop as opposed to probable cause to arrest, the general rule under ordinary circumstances, these extreme measures, pointing guns at people, handcuffing them, making them lie in the street,
well, the jury
are not allowed.
The jury instructions presented the special circumstances as an exhaustive list, and I thought that in response to Judge Forrest's question that you're saying that it's not an exhaustive list, but I know you wanted to save time and you're down to a little over 3 minutes.
Just let me say about that, the jury instruction that I submitted was lifted verbatim from the district court's summary judgment order saying, this is the law that under ordinary circumstances, I actually deliberately lifted his quote so he couldn't say that's not the law, because that's what he said the law was. It would have been easy if somebody wanted to modify, put in such as, or an additional factor. So yes, thank you. I'll reserve my last 3 minutes. Thank you.
All right, thank you, counsel.
Good morning, Your Honors. My name is Sarah. You guys will represent the defendants in this manner.
Can you speak up, counsel?
Oh, I'm sorry, Your Honor.
We've been having some sound issues
Okay,
this
I'm
week.
sorry. I'll try to speak
If
up.
you can move the
Oh,
mics
sure.
closer.
Okay. I'm sorry. So I'm glad that Mr. Burton mentioned that there was a Monell trial here, because that's what I'd like to discuss a little bit with the court this morning. Unlike in Green, here, a properly instructed jury found that there was no Fourth Amendment violation arising from the high-risk stop.
I'm looking at the verdict form, and how do we tell from the verdict form that the jury found no constitutional violation at all versus that there was a constitutional violation, except it wasn't pursuant to any official policy and practice? Just the way the question was presented here. Did the police officers, acting individually or together, while following an official policy, practice, or custom, deprive the plaintiffs of the Fourth Amendment right? So the way it's phrased, checking and answer no doesn't really answer the question.
Well, I can lay a little, I'm sorry, Your Honor. I can lay a little foundation and answer the court's question. So the jury was instructed that the LAPD had an official policy that allowed officers to conduct a high-risk stop of suspected stolen vehicles after considering the totality of circumstances. And that's at jury instruction number 23, the city supplemental excerpt of record 32. Then the jury was further instructed that the officers acted pursuant to that policy when they detained the plaintiffs. Again, jury instruction number 23 at SER 32. So the jury did receive that information. The jury was directed to understand and accept that when the officers detained the plaintiffs, they were acting pursuant to that policy, and the jury saw.
So let me back up. I just want to make sure that I understand your arguments on this point. You're saying that let's assume that we do find that qualified immunity was improperly granted to the officers. The verdict form as it stands still stands for the proposition that the jury found no constitutional violation despite the wording because of the way the jury was instructed?
Exactly. That's exactly my point. And the jury did see all the body-worn videos here. They heard from all the plaintiffs. And
But the verdict form itself is ambiguous, right?
I wouldn't say it's ambiguous given how the jury was instructed. The jury was told that the officers were acting pursuant to this policy that allowed them to conduct a high-risk stop of a suspected stolen vehicle after considering the totality of circumstances. And they found no, and they didn't struggle either. And the jury instructions were also perfectly appropriate here. They instructed the jury to take in consideration the totality of the circumstances and the intrusiveness of the stop. And the jury was told that they should, in determining whether a seizure was reasonable, they should consider the number of officers present and whether weapons were displayed. They were also instructed to consider the methods used in conducting the stop, the length of the stop, and in determining whether or not the plaintiffs were subjected to excessive force. They should consider the nature of the crime at issue, whether the plaintiffs pose a threat to the officers, and whether the plaintiffs were resisting or attempting to flee at the time of the stop. And those considerations are almost identical to the 4 Washington factors. And nonetheless, the jury still found that the officers acted lawfully here and didn't deprive the plaintiffs of their constitutional rights, even though it was undisputed that the plaintiffs weren't armed, uncooperative, or violent during the course of the stop. And just to talk a little bit about, address a little bit about what Judge Forrest mentioned about what Green says and the circumstances in our case, we contend that Green is very distinguishable both procedurally and factually, and that when we start talking about, well, here the windows were darkly tinted, nightfall was approaching, things like that, Green doesn't cover those circumstances. And although
The windows were tinted, but the officers saw before they effectuated the stop that there were 2 women seated in the vehicle. Is that right?
well, that's a little interesting. Not necessarily. They saw through the windshield, but they didn't see the third person in the back seat. And so the jury heard that when Officer Meneses, and this is on the body worn, by the way, and the jury heard this, that when Officer Meneses ordered passenger exit the vehicle, 2 people came out to his surprise, both the front passenger and the backseat passenger. So they didn't know how many people came out. And then they had them walk backwards to them so they could do a little cursory pat down and detain them briefly. And so that's another interesting point here, is that because the windows were so darkly tinted, the officers didn't know how many people were in there in this large, full-size Suburban. And but I want to emphasize something, though. The officers didn't conduct a high-risk stop of this vehicle because the windows were darkly tinted. They conducted a high-risk felony stop after consideration of the totality of the circumstances. That's not in dispute that they took the totality of
But it comes down to what is that totality that they're thinking about. And I think I'm having a hard time reading our case in Washington and then the Green decision to not say suspicion of a serious felony charge isn't enough. You've got to have something else that sort of indicates you've got a reasonable ground to be concerned for your safety as officers. So they have clear suspicion, I think probably stronger suspicion in this case than in Washington or Green in terms of what they thought the criminal activity might be. So that's really strong in their favor. But then what's the plus? What else? And it's the tinted windows and what?
their training and experience. So the officers.
But that comes back, the training and experience is tricky, right? Because that comes right back to, we suspect this crime, and in our training and experience, this crime means, people who are violent do this crime. How do you make that argument with Washington and Green that says suspicion of a particular crime isn't enough? I mean, Washington in particular, the suspicion of the crime there was armed robbery. There was no ambiguity about whether that suspected crime would be violent or not. Here, that's not true. I mean, you can steal a car in a violent way or a non-violent way.
Well, the officers testified, unlike Washington and Green, the officers did as much investigation as they could before pulling over this vehicle, and they needed to look at the registration and the VINs to determine whether or not it was in fact stolen. So those two cases, improper investigation, inadequate investigation on the part of law enforcement. But the officers did testify, and the jury did hear, and this that the officers had specific experiences when they pull over suspected stolen vehicles, of recovering tools and weapons and tools that could be used as weapons, and how the car can be used as a weapon.
Well, let me read you this passage from Green. It says, while the crime at issue, stolen vehicle or plates, was arguably severe, there was no indication at the scene that Green posed an immediate threat to the safety of officers or other. Were there circumstances here that indicate that the driver or passengers, for that matter, pose an immediate threat to the safety of the officers?
Well, they didn't know. I mean, they didn't know until they pulled everyone out and cleared the vehicle themselves. And if you watch the body worn, you see the officer saying, hang on, we got to clear this trunk before we determine that the car is completely empty and that the situation is, we've got this under control.
And once they pulled all the occupants out, were they continually detained and handcuffed?
Yes, during the course
while the officers investigated the issue of the license plates.
Yes, they were.
And was there anything that justified that?
Well, they were continuing to determine whether or not the car was stolen. So the officers testified they'd never seen this